Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you. This is the March term of the Court of Criminal Appeals in the Western Section. On the panel today, to my right will be Judge Tim Easter from Williamson County. To my left will be Judge Ross Dyer from Shelby County. I am Kerwood Witt. I am from Monroe County. Call our case, please.
State of Tennessee versus James McClain.
Arguments will be 20 minutes aside. If the attorney for the appellant wishes to reserve a portion of that time for a rebuttal, please make your announcement at the beginning of argument. Okay. Mr. Camp, you may proceed.
Thank you. Can your honors hear me okay?
Yes.
Good. Okay. Good morning, your honors. May it please the court. Of course, my name is Alex Camp, and I represent the appellant, Mr. James McClain. At this time, I would request to reserve 3 minutes for rebuttal.
All right.
Thank you. Your honors, this is a situation coming from Circuit Court in Madison County, Tennessee, Division III, before the Honorable Judge Kyle Atkins. James McClain was a named defendant in a trial where he ultimately represented himself pro se. He was charged initially with a 3-count indictment of violation of order of protection, coercion of a witness, and aggravated assault. There are 2 issues that I want to argue to the court here today, although I cited in my brief 3. I think that I would prefer to rely on the sentencing issue at the briefs. I think that's succinctly detailed in the brief. However, the 2 issues that I think are critical for the court's consideration here today are the issue of an involuntary waiver of trial counsel, as well as the impermissible amendment of the indictment cover page to reflect a separate charge presented to the jury. And so, beginning with a brief statement of the facts, Mr. McClain was in a relationship with a lady named Shelley, and they had been dating for about 18 months. And the relationship, according to Miss Shelley, was tumultuous. It at times was abusive, as she described. And ultimately, one night took place at a bar called the Office Lounge in Jackson, Tennessee. He was alleged to have assaulted her. She suffered what amounted to a serious bodily injury, and of course, charges ensued. Mr. McClain was arrested. Testimony came out about issues of her recanting, doing notarized letters, things of that nature, that provided some impeachment material for Mr. McClain and provided some notion of defense about the facts and what actually took place. However, Mr. McClain suffered some ill relationships with some of his trial counsels that were appointed. He had all appointed counsels throughout this process until he ultimately represented himself. And what the record reflects is he had 3 trial attorneys that were all dismissed prior to the trial beginning. Now, what's important, where we go now to, is the beginning day of trial. Okay, and Mr. McClain is having a colloquy with Judge Atkins. And Judge Atkins' conversation with Mr. McClain is stemming from him voluntarily waiving his right to counsel. This has become the issue that Mr. McClain has presented before the court. Judge Atkins goes into asking Mr. McClain a series of questions about determining his voluntariness and his intelligent waiver of this counsel. Now, what's missing, and I think critically so, because this issue wouldn't be before the court here today without it, is a written waiver to that effect. Rule 44B1 or B2 rather indicates a waiver of counsel shall be in writing. There is no waiver that exists. I think that the state on the opposite side stipulates to that fact, and so it becomes an analysis about whether or not this was intelligent and voluntarily waived, absent a written waiver. That creates a certain degree of presumption, I would add, and this is our position in favor of Mr. McClain's trial rights and Sixth Amendment constitutional right being violated. There is a requirement, Your Honors, that an unequivocal waiver ensue in order to proceed forward in trial pro se. Mr. McClain muddied the waters up that morning in whether or not that notion of that waiver was unequivocal. And I cite throughout my brief some examples of how ultimately his representation amounted to, quite frankly, ineffectiveness.
Mr. Camp,
there was several.
Mr.
Yes, Your
Camp,
Honor.
So, but this didn't just start the day of trial. This was a long, drawn-out process history in this case where, despite having appointed counsel, your client continually filed pro se motions representing himself, for lack of a better way of saying it, and saying that guy doesn't represent me, all of these things up to the day of trial where he had elbow counsel, but then even then said, this guy doesn't represent me. I don't want him here. I'm paraphrasing. I don't remember all the exact quotes, but that's basically the gist of his commentary. And so the trial court removes him and says, fine, we're going on our own. And I get your argument about written waiver, but at some point in time, after this has been going on for so long, hasn't the defendant made it abundantly clear that he wants to travel on his own? And at some point in time as well, the second part of this question is, we can't let the defendant hold the system hostage as he tries to play games with, I want this person, I don't want that person, I want to represent myself. Oh, wait, now I'm in the middle of trial, I don't know what I'm doing. I mean, all of these things were discussed with him by the trial court. So how does this cumulative of all of this not get us past what you're arguing?
In essence, I'll begin by answering your question related to the pro se motions filed by Mr. McClain that would indicate a want to waiver of his right to counsel. Something that's unique, I think, that needs to be presented before the court is this notion that I see several times that the court relies on in State versus Burkhart, State versus Cole, that almost suggests that, to my understanding and my interpretation of its reading, that when an accused is represented by counsel, a pro se pleading need not be acknowledged. In other words, that counsel represents the client at that point in time. That pro se is not even really entertained, more or less, for lack of a better way to put it. Furthermore, I'll advise the court, he did have elbow counsel the day of, or advisory counsel, however you word it, the day of or the morning of his trial. And I would suggest to the court, I do disagree to an extent, because Mr. McClain very specifically said that he wanted to keep that elbow counsel there. The elbow counsel actually requested to withdraw because he claimed that Mr. McClain threatened to sue him. Judge Atkins had dismissed the elbow counsel at that point. Mr. McClain made an effort to object to that dismissal of the elbow counsel, but ultimately the elbow counsel was permitted to leave that day, and they proceeded to trial. And that's a distinction that I want to make that is different from the case cited from the state. There is a State versus Goodwin, State versus Battles, and Stampley versus State that is cited by the state as persuasive authority about this written requirement. What I'd advise the court is the distinction in all those cases from my client's case is they all had advisory counsel. Rather than the Battles case, the Stampley case and the Goodwin case all had advisory counsel. I'd acknowledge court even then in the Stampley case, the court allowed for an elbow counsel to remain and ensured the appellant had access to an investigator and the public defender's office throughout the whole course of his training and preparation for trial. Because the efforts are, you've got to take more than necessary steps to ensure that James McClain, in this example, knowingly and intelligently waived his right to counsel at a trial level.
Well, Mr. Camp, what other step could this trial judge have taken? What other step, given the history of this defendant, could this trial judge have taken? What's the trial judge to do, especially when he's got an officer of the court telling him he's threatened to sue me? He's going to sue me. And apparently those threats had been made to other lawyers too. What's the trial judge to do? And also, getting to your point of signing a waiver, isn't there evidence in the record that your client had refused to sign things in this proceedings before, either in the investigation or with the court? He refused to sign. And again, brings me back to my question, what's a trial judge to do?
Your Honor, without question, my answer to that is follow the rules of 44B2 of Tennessee Rules of Criminal Procedure, which states unequivocally, waiver shall be in writing. My understanding and interpretation and experience from law school to today is the term shall is unwaverable.
Don't disagree with you. I do not disagree with you on that.
That step was not taken, critically so, because throughout the course of this proceeding from that moment on, it was, I need a lawyer. I don't know how to do this. I can't get this evidence in. These letters are important. They're impeachable. I don't know how to present them. I need the rules of evidence. I'm sorry, Mr. McClain, you're going to follow the rules of evidence just like everybody else in our court. You're watching the struggle take place. This man, regardless of sympathy, has a constitutional right to be represented or make sure that his rights are represented. The efforts could be without question waived in writing. That writing didn't exist. Now, the other point to your add-on was he did refuse to sign a Miranda waiver during an investigation with Sergeant French, and it was something to the effect of under duress. That wasn't really explored much further. I can't really add to the specifics or context of his issue with participating in his Mirandizing. However, I would advise the court that it's always my advice to remain silent without counsel present. So in a way, he would have followed my advice in having refused to communicate with Sergeant French in that effort. That's neither here nor there, Your Honor. The position being, to answer your question as simple as I can put it, is he needed to have a written waiver to show us that it was completely without question.
Mr. Camp, let me follow that up.
Yes.
And I don't disagree with you. Shall means shall. I mean, it's a mandatory word. But, and I'm not saying this is your case, but at what point, though, is there a point at which we say, too bad? I mean, your client, as a hypothetical, he refuses to sign the waiver, but he keeps threatening he's going to sue anybody who's elbow counsel. You know, again, to my question earlier, he can't hold the system hostage. I mean, there's plenty of case law about, defendants playing games with the system and how we don't allow that. So at what point in time is there one at which the mandatory language of shall sign the waiver is superseded by we're done going through all this every time we set this case for trial and you object?
It's a good question, Your Honor, and it's subject to a lot of opinion and discretion in the way that you present it. And I was cleverly asked. But the notion that I think is key here is, for example, that hostage language you use. The State versus Battles case the state cites in their response. That gentleman, I think, clear from the record there, almost presented that fact specific as an appellate issue, a strategical issue. And that's unforgiven. That's not what the purpose of right to counsel's for, is to have a second bite of the apple if you fail the first time and your strategy pays off. The fact specific here, and the reason why this case is different than holding the court hostage per se, is because once they have that argument about, no, Your Honor, I want Mr. Howe to stay with me to advise me, and he says it's too late. At that point, the judge, I think the court better said respectfully, erred in it, because it should have utilized discretion, saying, you know what, this has gone far enough. There's not a clear issue here. If we go forward, I'm subjecting this gentleman more or less, even though he's expressed otherwise, to represent himself without the assistance of advice from counsel. The court should have reset that case at that point. Or
what if the trial judge had handed him a waiver form and said, okay, and he said, I refuse to sign it, and again, I'm adding facts. I understand that.
Yes, sir.
Here's a waiver form. You say you don't want elbow counsel, which I know that's not what he said. Either sign it and your client had refused to sign it. Could we then say that's enough at this point and you're going to trial alone because you're refusing to sign it, but you say you don't want counsel?
It would certainly demean my argument.
Okay.
And I would concede that, Your Honor. I would. In reality, that's the court, and I quote Goodwin, taking more than necessary steps to ensure that an appellant knowingly and intelligently waived his right to counsel at the trial level. If the judge goes as far as to accommodate and the defendant still doesn't want to participate to that effect, I can't argue that point. He's done what he needed to do. Unfortunately, here it doesn't appear that every effort was made necessary. There's a critical B1 or B2 I'm relying on here. And so on that basis, the only reason why I continue on with this is related to this next issue. We see how this plays out throughout trial. It's hard to read. I'm sure it was harder to watch. It's a 2-day aggravated assault trial, Your Honors. And typically speaking, in trial practice, there's a victim here. It doesn't take a lot to put on proof. But the reality is my client could not. It was painful to try to see him try to get stuff in. He didn't know how to do it. They wouldn't allow him to put it in, and rightfully so. A lot of the objections were correct. And then in addition, there's this notion that they amended the indictment in violation of the court's order. And I cite that on my second paragraph. The state cites Rule 7, which is a unique rule. I'm sure it's not cited very often, to amend the indictment cover page. Initially, it said violation of order protection. They had amended it to an aggravated assault. So he's facing 2 counts of ag assault with a coercion of witness on count 2. And the court on June, and I want to make sure I get this correct, 24th of 19, entered an order denying that motion. However, on the day of trial, I put in some language that was stemming from the colloquy that Judge Atkins resuscitated with McClain about waiving his right to counsel. McClain was obviously very confused because the issue is the judge was telling me, you realize you're charged with 2 counts of aggravated assault, Mr. McClain, and 1 count of coercion of witness. And he said, 2 counts? What are you talking about? I'm not aware of this. He said, well, 2 counts of aggravated assault. He said, how is that? In the indictment, it just says 1. Well, Mr. McClain's right. The first charge was violation of order protection. And the court read the 3 counts of the indictment. Somehow this language got amended in violation of this order. That's something that, in reality, without representation and without an unequivocal waiver, perhaps maybe trial counsel could have protected his rights, which is the purpose of his 6th Amendment Constitution right. And so in that essence, that's just another example of many to how Mr. McClain suffered a certain degree of prejudice by not ensuring, that his rights were fulfilled unequivocally. And so, Your Honors, on that basis, you have to show unequivocal clarity of an intended waiver of counsel. That gets essenced through a written waiver. However, the morning of trial, ultimately determining that he's going to go forward, maybe even goes into a degree of that timeliness aspect as well. And so for all things considered, a totality of the circumstances, Mr. McClain, if he gets the opportunity to go downstairs and retry this case, if he wants to represent himself again, he needs to sign a written waiver, and that's a conclusion of this case.
Mr. Kemp, down to your reserve time.
And matter of fact, I was about to rest at that point. Thank you, Your Honor. That's all I have.
All right, General Wardle.
Thank you, Judge. Your Honors, Jonathan Wardle for the state of Tennessee. Can you all hear me fine? Thank you. I have to say, Judge Witt, it's nice to see you. I see Judge Easter and Judge Dyer more often than I get to see you, so it's nice to see you today. And I want to start with thanking y'all for having these Zoom arguments. I know it's interesting. I know that I struggle a little bit not being in person, but I'm just grateful that we have a chance. So thank you all very much for that. I'll begin with that last issue about amending the indictment. The state simply did not amend the indictment. Mr. McClain seems to be trying to take advantage of a simple mistake on the cover page. The cover page of the indictment said, and this is page 28 of volume 1, 28 of the technical record. The cover page, says he's charged with violation of order of protection in count 1. But the actual indictment, the actual charge doesn't say that. It says aggravated assault. It cites the aggravated assault statute. I assume the confusion came because it was aggravated assault by violating an order of some form of restraint. So I assume that's where the confusion came from, but the fact is the actual charge was always aggravated assault. And that's page 29, volume 1, page 29 is where that charge is. The state did file a motion to amend cover page. It was interesting in that the motion said this is clearly solely to avoid confusion. It pointed out that it had always charged only aggravated assault, that it only wanted to amend the cover page. And again, it says, I think 2 or 3 times in the motion, this is just to avoid confusion. That was it. The trial court denied that motion. We don't have the transcript of the hearing where the trial court denied that motion. And I'll come back to that a little bit later. But we don't have the transcript, so we don't know why the trial court denied it. But it did. It doesn't matter. The state didn't do anything different at trial other than present the actual charges to the jury. So unless there are questions on that issue, the simple answer to the appeal on that issue is the state did not amend the indictment. It instructed the jury with what was actually charged.
Count 3, aggravated assault by serious bodily injury.
It was count 1 was aggravated assault, and count 3 was also aggravated assault. There were alternate theories.
But 1 was by violation of some sort of order of protection.
Yes. That was count 1.
The other one was serious bodily injury.
Yes, Your Honor. Correct.
And at the end of the day, they merged.
Correct, Your Honor. Okay. Unless there are further questions on that issue, I'll turn now to what seems to be the meat of the appeal. That's this self-representation issue. And I'll admit my personal sympathies go out to a defendant who's not represented, but that was his choice. And it was unequivocally his choice. Later, he had what we sometimes hear referred to as buyer's remorse. But having buyer's remorse in the middle of trial doesn't change the fact that he made the choice. And he put the court in a difficult position. So I want to start out this portion of the argument by pointing out that we're not talking here about a constitutional violation. Right? The violation of the right to representation or the violation of the right to represent yourself can be a constitutional violation. But that's not what it's at issue here. The record shows that he knowingly and voluntarily waived his right. What's at issue is a rules violation. The court allegedly did not obtain a written waiver. And at this point, I'd like to, Judge Dyer pointed out and Mr. Camp argued about whether all these pro se motions could count as a written waiver. And in my brief, I discussed cases where it could be considered that. And so the state does not actually stipulate or concede that there was no written waiver because it's possible to conclude that all of those pro se writings amount to a written waiver. Right? The state does concede that there was no form waiver signed by defendant. But the bigger point, and the state doesn't focus a whole lot on that because the bigger point is even if there was no written waiver, number one, the constitutional right was not violated because the waiver was so clear. And number two, any error was harmless. And the burden as a non-structural, non-constitutional error, the burden is on the defendant to prove that it more probably than not affected things here. And here it's clear that he would not have proceeded with counsel. I want to go back to what I mentioned before about the hearing. There was a hearing, and I assume they were the same date. Looking from the record, it appears that they were the same date, the same hearing. One is where the trial court denied the motion to amend the cover page of the indictment. The other issue that appears to have been brought up at the same time was Mr. McClain wanting to represent himself. Right? We don't have a transcript of that hearing. There's reference to it throughout the first day of trial. So we know that that was discussed. And without that, we can't fully review exactly what happened, what was before the court. What we do know is that the very first thing the court takes up on the first day of trial is Mr. McClain wanting to represent himself. He talks about it, unequivocally waives, and the court does what the court is not required to do, but often does, and that was appointed, at that point, appointed counsel as elbow counsel. A few minutes later, as they're discussing things preparatory to trial, counsel stands up and says, "Hey, he's threatening to sue me, Judge." And at that point, more discussion ensues. And it turns out Mr. McClain was not only threatening to sue him, but then said, accused the court of appointing only racist lawyers, only biased lawyers, only lawyers that would conspire with the state. He accused his elbow counsel of conspiring with the state. And the court, tried to resolve these issues. But finally, the court said, you've created a conflict of interest. And this is on volume 4, page 44. In fact, I will read that here for the court. It says, that puts you in direct conflict with him, which means I can't leave him. Right? And then Mr. McClain's response is, I'm going to sue the next attorney because you're going to appoint another attorney that's going to be biased and racist and discriminative too. And this goes on, right? The court's hands are tied. He's got a conflict. He's now manufactured a conflict of interest with elbow counsel. So the court has to let elbow counsel go. He's threatened that he'll sue any other attorney that's appointed. There's only one attorney that he said he would accept, and that attorney had already declined the representation. So the court here is bound, can't do anything. Nonetheless, he gives Mr. McClain the choice, and this is, I think it's on page 48 of volume 4. He gives Mr. McClain the choice. I've got to let this counsel go, but we can appoint another one. We'll have to continue the trial. So what do you want to do? Do you want to continue the trial and have another attorney appointed, or do you want to proceed today? And Mr. McClain says, let's go on today. That's what he wants to do. Right? He has no right to the appointment of elbow counsel. He's already waived his right to the representation of counsel. And the court is bending over backwards trying to work with what can only be described as, and this is a word I learned long ago, the obstreperous lawyer. Well, here you have the obstreperous defendant. Right?
Should our assessment of this waiver be informed by the defendant's performance during trial?
No, Your Honor. No, Your Honor. The case law is absolutely clear on that you cannot take that into account. The question is whether he waived it voluntarily, and that's a pre-trial question.
Well, part of the waiver protocol that the trial court is supposed to go through is to make some assessment about the defendant's ability to represent himself. And so to that extent, should we look at how well he did that during trial?
Again, Your Honor, and I wish I had written it down. I was just looking at a case last night preparing for this, and I didn't look it down. But it's a published opinion that talks about how you can, and this goes, it's a couple of decades back, which is why I didn't write it down. I usually try to bring up more recent cases. But it talked about how the consideration of how you performed at trial does not have a bearing on this issue. The court is required to consider, is he intellectually capable? Does he have the education? But the main issue is not, can you represent yourself effectively? That's just not the issue. The issue is, are you making a knowing and voluntary waiver of your right to counsel? And it makes sense why. Otherwise, someone who wants to represent themselves, but maybe only has an 8th grade education, the court could just deny them that right. And that would deny a constitutional right for an invalid reason. You have a right to represent yourself just as much as you have a right to be represented by counsel. So no, the court is not supposed to look at, well, they did a bad job at trial, so really maybe this was a mistake. That's just not the analysis. Here, Mr. McClain, over and over again, evidenced his desire to represent himself, and he wouldn't work with any attorney. When given the option, he chose to go ahead without counsel instead of waiting longer. That was his choice. In retrospect, it may have been a foolhardy choice, but it was his choice. Another phrase that I learned long ago when I was starting out practice was architect of your own agony. Again, I'm sympathetic to Mr. McClain's position on appeal, but it was his choice, and the trial court is kind of hamstrung. So I guess Judge Dyer called it holding the system hostage. I think that's what you have here. If you would allow Mr. McClain to go back and have yet another try, it would be saying, well, okay, you could hold the system hostage by, if you're difficult enough, and that's not the law. Unless there are further questions on this issue, I think I've hammered the points I want to make. As you review the record, you'll see, and I included a lot of it as an appendix to my brief, but you'll see in the transcript that he unequivocally waived his right to counsel. He was nonetheless given elbow counsel, which is not constitutionally required. Then he threatened to sue and eventually created a conflict of interest with that counsel, so the court had to let counsel go. And I'll point out, the court didn't immediately let counsel go. The court tried to let counsel stay on, but once the conflict was created, the court said, my hands are tied, I've got to let him go. And then Mr. McClain went on to eschew that he would sue any other counsel. Right? There's just really nothing more the court could have done here. And to the extent there is any, to the extent this court finds that there was no formal written waiver, we would subject that is harmless, given his clear invocation of this constitutional right to represent himself. Unless there are further questions, we would ask that you affirm.
All right, thank you. Mr. Camp, you have 3 minutes.
Thank you, Your Honor. The question I want to drive home here today for the court's consideration is, do these facts follow in line with State versus Battles, where the defendant tried to undermine the court in an effort to preserve some appellate right? Or did the defendant really have some degree of struggle and complication with his relationship, attorney-client relationship? I would argue the latter. I'd advise the court, State versus Fletcher, which is a case I cited that this honorable court handed down, gives us 3 prongs of consideration in the right to exercise self-representation. First of all, the defendant has to timely assert that right to proceed pro se. Okay? At the point in time where he's proceeding truly pro se, the jury comes out the door and they're ready to have the jury trial. It's the morning of trial when the elbow counsel's gone and Mr. McClain is by himself pro se. That timeliness, I think, is really called into question there. Clearly and unequivocally asserting that right. Evidenced by written waiver doesn't exist. Him wanting the elbow counsel to remain does. And the reality is, and I'll finish by stating volume 4, page 36. So let me ask you this, the court says, do you want me to remove him as elbow counsel here today? That's a simple question, yes or no. No, Mr. McClain says, I want to proceed today. It's time to stop, the court says. You haven't answered my question yet. And frankly, I think you've now answered my question for me. I'm going to relieve Mr. Howe. If you want to just represent yourself here today, you can. Mr. McClain says, I want to represent myself and he can be my elbow counsel. He's not going to do that, the court says. I'm done. He said, well, I object, Your Honor. I don't want Mr. Howe relieved. You can't object to it. End of story. And so finally, the knowing and intelligent waiver requirement, the facts show my client is of an 8th grade education. It calls into question him intelligently waiving that right to counsel. And ultimately, there is no true clarity based on him that morning wanting to have assistance with him, but not being permitted to do so fully, whether or not we could fully rest on and feel comfortable knowing that Mr. McClain's rights were protected there. And that's what this is all about, is making sure that on a direct appellate review, my client was afforded all rights and all fairness to him. I think his rights were violated, and for that reason, we'd rely on and ask for reversal of his conviction, get this right downstairs. Thank you.
Mr. Camp, let me ask you one question before we conclude.
Of course.
So maybe it could have been handled better, that morning of trial. But what's your response to the state's and the trial court's comment that by threatening to sue elbow counsel, he created a conflict? So even if he all of a sudden objected because we're getting ready to go to trial, does the lawyer not now have a conflict where he can't serve as elbow counsel?
Your Honor, In that situation, of course, from an ethical standpoint, this was an oral motion, more or less, I suppose, to withdraw. There was nothing formally filed. Of course, my client alleged to have sued that Elbow Advisory Council. Does that create an inherent conflict in protecting and preserving his trial rights? I'm not sure what the lawsuit was relevant to. Was it relevant to ineffectiveness? Was it relevant to him encroaching on his property? The reality is, I'm not trying to play games with this. It's just in my position, words are words. I don't think there was really much action. My client had a right to an assistance of representation, and I'm not sure that right was fully waived that day. And I'm not sure if the court should allow my client to proceed not knowing that unequivocally. And it's better to err on the side of caution when you're protecting a right like that, because then you don't get an Alex Camp up here asking you to reduce or reverse this case because nothing exists to show us to suggest otherwise.
Thank you.
Thank you.
All right. Well-argued case. The court appreciates counsel's arguments today, and that concludes the argument in this case.
Thank you, Judge.
This honorable court of Tennessee is now in recess.